Welcome back, viewers, to the Personal Injury Law Show. Before the break, we're talking about air carriers liability. Now, we're going to do the case of Brannock. Who's going to give me the facts of that?
I can give you the facts, Tony. Back in May 2007, Mr Brannock was going on a Jetstar flight from Brisbane to Adelaide, and he'd presented his boarding pass and he'd headed down the hallway and down some stairs to find the exit from the terminal to the aircraft. He unfortunately got a little bit lost and made his way back up the stairs to be confronted by other passengers who said that they knew where to go. So they directed him back down the stairs, and whilst walking back down the stairs, he fell to the foot of the stairs and he was injured. And he claimed compensation from the air carrier's liability because he was technically between the terminal and the aircraft. And
what happened?
Well, at first instance, he was successful, Mr Brannock, I think in the District Court of, I think it was New South Wales.
New South Wales, yes.
And then went to the Court of Appeal, which was appealed by Jetstar, and unfortunately, Mr Brannock failed. They found that it wasn't an accident under the Civil Aviation Carriers Liability Act. Well, they found that it wasn't an event that was unusual, unexpected, or outside, I suppose, the actions of the plaintiff.
So it was nothing that the airline did to cause his injuries? That's
right. There was nothing external to the plaintiff which caused his injuries, and there was nothing that the airline did or didn't do to cause it as well.
Can I give an example? I was on a flight recently where one of the air hostesses spilt apple juice all over me, and I had a 10-hour flight and I wasn't happy about that. You wouldn't have been happy? No, I was very upset, actually. And she kept saying it was an accident, and I said, yeah, no worries, but I've still got to travel in these conditions. But assuming that was coffee, and I would have been burnt because coffee is very, very hot, would I have been able to claim?
I think you would have definitely a chance at a claim. I think Alice, you've had a similar claim.
That's actually right. I represented a man who that exact thing happened to. He had ordered a coffee on a Jetstar flight, and the air hostess passed him the coffee. He took hold of it and put it on his tray table in front of him, and then there was some movement somehow and the coffee spilled all over his legs, and he suffered second-degree burns as a result of that. And he did recover some compensation from the airline.
But what's important is that there's no threshold on claiming. So you don't need the 5% under the public liability laws and Wrongs Act.
As long as you have a medical report detailing the injuries that you've sustained, you can make a claim.
That's and that's very, very important.
What's important too, Tony, is that there's a 2-year strict liability in making
I was going to come to that.
Yeah, I just thought to make that clear.
So the key elements to these claims is there's got to be an accident external to the passenger.
Yep.
And secondly, you've got to make sure you lodge it within 2 years, and there's no right to extend.
There's no extension.
Right. No extension.
Unlike in work cover and public liability where you can make applications, there's no applications.
It'd be too onerous on the airlines, I guess. They'd have to keep records for forever.
Yeah.
Look, can we go to the next case? This is an interesting one. Who's going to give me the facts of Airlink and Patterson?
I think that's Alice.
Alice.
Airlink and Patterson, Tony. Very interesting case, and not too dissimilar from Brannock. Mr Patterson was on a flight and he was disembarking from the aircraft this time. He had made it all the way to his destination, and he was coming down the back staircase from the aircraft to walk onto the tarmac. It was an aluminium staircase, and whilst he was walking down that staircase, he lost his footing and he fell and sustained injury to one of his legs. And the really interesting thing about this case, Tony, was that the court found at the end of the day that it was an accident external to the passenger because there were some facts brought into argument regarding the movement of the staircase. It had moved for some reason whilst he was trying to climb down.
And of significance, Nods, he did not have to show what caused the movement.
No, all he had to really prove was that it was peculiar to him. He said it was outside, I suppose, his control, and that he didn't cause it, which was enough.
Surprisingly, they argued his weight.
That's right. They did argue his weight, Tony, because he was a little bit of a bigger man, and they were a little bit worried that it was his weight that caused the movement. Yes, I know I'm being kind, but at the end of the day, they found that it was external to him. It wasn't him that moved the staircase. It was something to do with the aircraft, and that's where it stops. That's really as far as he needed to go in terms of liability.
It's difficult, Tony, in these cases. I think, we look at it as if it's a negligence argument, but it's not. But I think that's the way the courts are, not confused, but they're torn about how to actually assess these cases, because you are still looking at some sort of fault.
It was very bitterly contested. It went to quite a few courts, that case.
It did. It went right through to the New South Wales Court of Appeal, Tony.
Let's turn to third parties. And what I mean by that is, let's say an aircraft, like this stunt show, crashes injuring third parties. What are the rights of the individuals that have been affected? Now, there's an interesting case of Cook, an ACQ Proprietary Limited, and Air Care Maury Proprietary Limited. Who's going to give me the facts?
Well, this is a case in which I think it was a crop dusting aircraft was spraying a cotton field, and unfortunately it struck some power lines and crashed to the ground. And unfortunately, a conductor that was hit in the course of the event fell, I think, from about 1.5 metres from the ground. And as a result, the company that services those conductors were called. And the plaintiff, in this case, Mr. Moore, was told to go out there and have a look. Was specifically told, though, not to go near the conductor until they had it, I suppose, isolated and it was safe. But either way, he went out, wanted to assess the damage that had been caused, and in doing so, obviously, I think was electrocuted or sustained some really serious damage.
That's right.
And what happened in court?
He was initially awarded, Tony, over $900,000 in damages, but the case, of course, was appealed, and it went all the way to the High Court as well. And they argued generally on different grounds, the two different defendants, because obviously they were concerned with the fact that Mr. Cook, despite specific instructions, had gone up to the aircraft before the time specified, which contributed to him sustaining injury.
And I think, Tony, they felt that it fell outside. I think that the Act says that it's got to be as a result of an impact of a plane, and they thought that in him going out there and should have obviously held back, that it fell outside the scope of the Act.
But the court did say that the fact that the aircraft was the reason why he went out there. It was caused by the aircraft.
Oh, look, he was successful in the end, but the defendant tried to argue that it fell outside the scope of the Act.
Okay.
If there's any lessons you'd want to tell the public, Alice, what would you say? What's the most important thing dealing with these sorts of cases?
I would say, Tony, actually the most important thing is the 2-year time limitation, because it is so strict, but it's also important to really take note of the circumstances, because the courts are really preoccupied with this idea of accident, and for third parties, they're really preoccupied with the idea of exactly when it happens, because as you know, Mr. Cook wasn't hurt exactly on impact, but it's as a result of the impact that he was even there in the first place.
And Nuntz, what would you say?
Look, similar to Alice, the 2-year time frame is crucial. So you don't get a second chance, so you can't take it for granted.
I think it's very important how you verbalise or how you report the incident.
Yeah, of course.
Because if you say, I spilt the coffee on me,
That's right.
I think you're in trouble.
You'll be in trouble.
If you say, I tripped, I'm not trying to help people, basically.
Yeah, no, we understand.
But, at the end of the day...
It's so technical that
it is technical.
One line can unfortunately be the end or the start of your case. So it's get advice and
I think it's important that you don't use the words loosely. And we get that a lot in the workers' compensation area, where people fill in claim forms and they're not accurate in the way they got injured. But look, it's been very interesting. I want to thank you for coming on board, Nuntz and
Alice. Thank you, Tony.
It's always a pleasure. So viewers, please don't go away. Stay tuned. We're going to a sponsors break and we've got Kathy's mailbag just after the break. Thank you.